Today I will discuss some common sentencing errors that I see criminal defendants and their attorneys make in district court. I've represented over 800 clients in the 86th District Court. I will discuss some of the errors defendants make when they talk to the judge before sentencing. Errors that cause more jail time or a longer, more difficult probation for the defendant. My name is Matt Benedict. I am a Traverse City criminal lawyer. I have been practicing law since 2001. Before I get into the sentencing errors that I see in district court, I need to educate the viewer a little bit about the general concepts of the 86th District Court. After a guilty plea or a conviction from a trial, there is a phase called sentencing. At sentencing, the judge will tell the defendant what will happen to them. Either incarceration in jail, probationary term, or both. Every defendant at a sentencing has an opportunity to speak directly to the judge. What the defendant says to the judge may have a dramatic impact on their sentence. Most people with a criminal history start in the district court. And what I mean by that is they start small, then they move up to felony cases. Of course, that's not always the case, but for the majority of the people that are within the court system, they always seem to start in district court. For a lot of the criminal defendants in district court, this is when their problems that contributed to their criminal charge are first starting to take over and or show up. First offense drunk driving is handled in district court. So a first offense drunk driving is usually an indication that the defendant's consumption of alcohol is becoming a problem. District court is also where we will see 17, 18, 19-year-olds steal something from a store. District court is a court of intervention. And what I mean by that is that the judges and the probation officers, they all know that most people, their first stop in their criminal career is in district court. So they want to intervene right now. They want to get to the root cause of what's causing the criminal behavior and deal with it right now in misdemeanor court. Every district court judge wants to help the defendant in front of them. They want to straighten this person out and get them back on the right track. Now keep in mind, a person with a lengthy criminal history is not going to be treated the same as someone who has only a few criminal convictions. For those people with a lengthy history, the court and the judge are probably going to just do very little to try to rehab the defendant. The most important concept in district court sentencing is that the district court judge wants to intervene and help the defendant. The defendant's words in court should address or appeal to the judge's desire to help this person in front of them. Alright, so here's my list of mistakes I see in district court. These are mistakes that people make while they are speaking to the judge at sentencing. The first error is the "I made a mistake" people. These are people that will stand in front of a judge and they will say, "Judge, I made a mistake. I'm real sorry about it and I want to move on with my life." This is a middle school "I'm in trouble" mentality. In essence, there's no attempt to communicate a desire to change to the judge. It is obvious to everyone involved that the defendant made a mistake. He was arrested, charged, and convicted of a crime. There is no appeal to the judge's desire to intervene and help them. Instead, what comes across is perhaps the defendant doesn't get it, doesn't understand this. Number two, the litigator is the person that wants to continue to talk about the victim and how the victim contributed to them getting arrested and convicted. At sentencing, when a defendant starts to talk about what the victim did or what the police officers did to them, in a sense, they're trying to legitimize or justify their actions, their criminal conduct. Instead of focusing on the future and what they need to do to stay out of the court system, they are still fighting the battle. The impression left with the sentencing judge is that this is a person that hasn't really accepted responsibility for what they did. And furthermore, as a judge, the judge must decide whether they want to use resources on a person that doesn't believe they did anything wrong. The judge will think that this is a person that will not do well on probation, and an alternative to probation is jail. Number 3, justification cloaked as honesty. Recently, I represented a client that was in high school, a 17-year-old in high school that got into a fist fight with another student. What had happened in this case is that the victim had bullied my client in school. And finally, the victim started to bully my client's girlfriend in school. So at this point, my client lost his temper and struck the victim multiple times. During preparation for sentencing, I asked my client what he planned on saying to the judge. And he told me he's just going to be honest and tell him what had happened leading up to the fight. I had to refocus my client. I pointed out to him that he was really trying to justify how and why he committed such a brutal attack on another person. I had to refocus this young man and get him to concentrate on self-reflection and how he could prevent himself from losing his temper in the future. My client's self-reflection about his anger issues demonstrated to the judge that my client would most likely respond well to probation and anger management instead of a jail sentence. Number 4, this is the defendant that doesn't believe they have a problem with drugs or alcohol. In every drunk driving case, the judge is provided with a drug and alcohol assessment prepared by the appropriate professionals. The person that doesn't believe they have a drug and alcohol problem will fail to address or discuss with the judge the treatment recommendations within the substance abuse report. Furthermore, this defendant will not appreciate how their conduct, the drunk driving, endangered the public at large. When a judge comes across someone who they believe doesn't think they have a problem with drugs or alcohol, the judge is likely to order more substance abuse testing and increase the requirements of this person's probation. Number 5, the defendant doesn't provide to the judge a picture of the impact associated with this conviction. If my client has a family, it is important to convey to the judge the hardship that my client's family has already experienced or will likely experience from this conviction. The purpose of conveying a big picture analysis to the judge is not a plea for leniency. Rather, it is to demonstrate to the judge that my client appreciates how his criminal conduct has affected all the people that he loves. This conversation with the judge will demonstrate to the judge that my client has experienced pain beyond the confines of the court and that my client will have strong motivation to never come back. Number 6 is a reaction to the victim or a victim's statement in court. Sentencing for domestic violence or assault and battery always includes an opportunity for the victim to address the court. The victim will approach the court, stand at the podium, and talk to the judge about the hardship associated with this conviction. It is very important for the defendant not to react to the victim. The judge and the probation officer are watching the defendant. Even the slightest body language is observed. I have been through this many times with domestic violence clients. The victim will say something that my client disagrees with, and they will immediately nudge me and start talking in my ear. They will even go so far as to ask me to set the record straight about facts that are not all that important at this point in the game. If there is a reaction to the victim's statement in court, it should be nothing other than a simple apology. Any other comments about the victim in court may result in a very angry judge, and that's something that no criminal defendant wants to happen. Thank you for watching my video today on sentencing errors. I am a Traverse City criminal lawyer practicing law in northern Michigan. If you are in need of representation in district court, please do not hesitate to contact my office for an appointment.